George writes in with a question about location releases and permissions. Hi, I'm Gordon Firemark, and this is Asked and Answered, where I answer your entertainment law questions so you can take your career in business and show business to the next level. So here's George's question. I'm a filmmaker and I have permission from a tribute band to film that at a concert at a theater in Connecticut. The theater said the band can be filmed there, but an agreement needs to be signed basically saying that the footage can't be used for commercial use or they will sue, or they want $800 to allow us to film there. Now it seems that this is not an issue of liability or they would demand the fee for insurance purposes. What right does the theater have to sue the band or even me for filming the band's performance in their theater? What rights do I have as the filmmaker in getting permission from the band to use them in my film while performing at this theater? Well, George, the band doesn't own the theater, so they don't have the right to grant permission to film there. Only the owner of the property can do that, and he can put whatever conditions on the filming that he or she wants, and that includes charging a fee. And it's common for location owners to charge a fee for the use of their premises. Filming on the premises without permission is probably going to be a form of trespass and could give rise to civil and maybe even criminal liability. So that's how they have the right to insist on a payment and to put other terms and conditions on things. But trespass is a state law issue, and it does vary from place to place, so you'll want to check with a local lawyer familiar with that issue. An interesting wrinkle, though, is whether using footage captured in a club or theater within the context of a film really amounts to something called commercial. In First Amendment discussions, where we look at government restrictions on speech, it generally wouldn't be considered commercial. That term would more likely apply if the film is being used to promote the band or a product or an album or concert tickets or something like that. So it makes sense to talk to the theater about what they mean specifically when they say no commercial use. But ultimately, I have to say, $800 is cheaper than any lawsuit you get involved in, even if you win. What's your time worth for defending against this? What's it going to cost to have lawyers defend you? What's it going to cost just to pay filing fees for the case? So the practical advice is pay the fee or don't use the footage, or don't use it in any commercial way, and be sure you understand what the theater means by commercial. Now, if you have a question that you'd like to see answered here in this feature, please send it to me at firemark.com/questions.